May it please the court, I'm Jeremy Durham, representing the appellants, and I respectfully request 2 minutes for rebuttal.
2 minutes, okay.
Procedural challenges aside, the core issue here is simple. Can Hendersonville enforce a zoning restriction against the rights of a property owner when the city itself cannot consistently explain what the ordinance means? Tennessee law says no, and we submit that any citation, injunction, or judgment based on this ordinance must be vacated. And because the injunction has already cost appellants tens of thousands of dollars in lost revenue, the city should be liable for those damages. According to the Tennessee Supreme Court, a property owner's right to own, use, and enjoy private property is a fundamental right. When government restricts that fundamental right, courts demand clear and express language in the text itself. According to Panhera-Ponde versus FSD Corp., Tennessee Supreme Court, just a couple years ago, restrictions in derogation of the right of free use and enjoyment of property are strictly construed and will not be extended to any activity not clearly and expressly prohibited by their plain terms. That principle is not limited to private covenants. Tennessee zoning cases follow the same rule. Ambiguous land use restrictions are construed in favor of the owner's free use.
Counsel, you started with procedural issues aside. I want to just quickly touch upon those. I know the centerpiece of your argument is related to the interpretation of the ordinance, but it seems you've raised, I think, 15 issues in your brief, and a number of those, some of them seem to disappear when we get to the argument section, and some have no supporting authority. For those issues where there's not authority supported, haven't you essentially waived that issue? I know that's not the centerpiece of your argument, but I'm trying to look at those 15 issues and figure out what really is before us here. And there are a number of them where there's not a case cited, a rule cited, a statute cited, and you make a contention. The law in Tennessee is X, or the law with regard to procedural requirements is Y, but there's not a procedural rule cited or statute. Are those arguments essentially waived here?
It's my position they're not, but we did have some constraints on the length of our briefs, and like no de novo proof. This started as municipal citations, so it's a de novo hearing. There was never any proof. Like personal liability was imposed without even any reference to piercing the corporate veil in the pleadings. There was no evidentiary hearing. There was a sua sponte, final judgment, permanent injunction. The overbroad injunction itself limits me from going to my own lake house. So I think those are some of the things that you're mentioning. I don't know if I had 15. There were quite a few, but just things that I just assumed might be straightforward. I could have not done. I could have done a better job, but no injunction factor analysis. It's just always been my impression that was supposed to happen. On October 7th of last year, the trial judge himself called this ordinance not a model of clarity, and earlier handwrote the word vagueness in reference to the same sentence. The court also resorted to the preamble and legislative history, materials it should not have needed if the ordinance were clear. Over the life of this litigation, the city has offered 3 different readings of the same sentence. The trial court adopted a fourth of its own. If 4 official interpretations of one controlling sentence are possible, the text is not clear enough to restrict a fundamental right.
Counsel, when you reference legislative history there in terms of the trial court's consideration, are you including the purpose language of the ordinance as part of what you're wrapping into that legislative history discussion?
It actually got a lot broader than that. There was the preamble, and then there was a letter written by some planning and codes person. It's very broad.
With regard to the whereas purpose language here, is that in a different category than general considerations of purpose, though? That's essentially adopted, right? It's approved. It's been sanctioned as a purpose. Now, we could talk about the value or how much that actually tells us, but isn't that a different type of purpose consideration than, say, the court trying to divine or decipher a purpose on its own out of looking at the legislative history of a provision? If a legislative body tells us these are the things we're trying to accomplish.
Your Honor, I could honestly tell you that I'm not qualified to answer that question. I'm not going to sit here and just give you a willy-nilly answer. I think it's a very astute question, and I wish I could give you a better answer. But the confusion related to the 4 interpretations was not only academic. It required 4 hearings and a homework brief on a Puerto Rico bankruptcy decision just to figure out what the sentence means. We submit that interpretation of what's prohibited should not be this difficult. In 2005, our state Supreme Court ran into a similar situation with a local ordinance when it decided Knoxville versus Entertainment Resources, LLC. And Your Honors, the Knoxville versus Entertainment Resources decision, it was not in my briefs. I have copies if anyone's interested, but it's squarely on point. It's something that was given to me recently. This is a direct quote, and I think it's very applicable. The inability of the officers charged with enforcing the ordinance to define its key terms weighs heavily against the ordinance's constitutionality. The Supreme Court went on to say, although due process does not require impossible standards of clarity, this is not a case where further precision is either impossible or impractical. The Supreme Court continued saying, quote, having considered the record and applicable authority, we hold that the ordinance is vague and unenforceable under the U.S. and Tennessee constitutions. They remanded it to Chancery Court for exactly what we're asking today.
With regard to the dwellings, the units, the properties at issue in this case, were there uses of the property that were not rentals of less than 30 days for each of the properties involved here?
Yes, Your Honor. There's supporting affidavits. We never got to an evidentiary hearing. It's my understanding of de novo review that for the city to win, there's got to be an evidentiary hearing.
But you provided affidavits that
Yes.
said that there were uses for more than 30 days for those,
Yes, and
for
there's
each
been
of the properties involved.
Yes, that is true. And that's happened even
And how many fell within that category?
at the time that I submitted. There was 2 for one property and 1 for the other. There have been several since, but this has been only being. I bought this property, my wife and I, there was 2. It was August of 22 and then September of 22. The dispute started just a few months later. It started with us just having one on the calendar when we first started, and then we had another one, then another one. So it's not exclusively for terms of less than 30 days. Also, the plain meaning canon. The key phrase is found in the ordinance's definition of a vacation rental. The relevant part is defined as a dwelling unit or other structure rented and or used exclusively by a person or persons for lodging for terms of less than 30 days. Under the plain meaning canon, the phrase used exclusively for lodging for terms of less than 30 days describes the use of the structure as a whole. So if the property has any long-term stays, as the judge just asked, or if it has any non-lodging personal use, it is not exclusively used for lodging for terms of less than 30 days.
Does that mean that if you had, let's say, a weekend where it wasn't rented and you brought folks up for a barbecue that weekend, does that take it outside the scope of the ordinance? So as a property owner here, that if there's or if J&J Ventures has a event that's a barbecue for, I don't know, friends and family of J&J Ventures, that you've taken it outside the scope of the ordinance?
That's exactly what I was about to say. And if you look at the statute, I mean, even for lodging, if you look at the ordinance, lodging is not defined. We've had actually what you're talking about, a family gathering where there was food. I didn't cook it, but there was food. They don't trust me on the barbecue anymore. But we've had people, because we own 18 properties, and we've had meetings there. We've done personal things. I mean, no one buys a lake house just to rent it out. I mean, it's 35 miles from our house. We've been there as a family, not as much as we like, but we have done that.
Is there any information as to those types of uses that's in the record?
Not yet. It was our position that we never got that far. We understood that in a de novo proceeding that this started as municipal citations. This was just, you have violated short-term rental, come to court. We then appealed de novo into circuit. Each citation we never got that day in court. We did the affidavits because we had the stays, but for my wife to not see patients that day and to let me I was expecting an evidentiary hearing, which I assumed would happen for the city to be able to carry its burden. So that is not right now. But the thing about for lodging, it's not defined. As I said before, there's lake houses. Nobody buys it just to sleep. There were meetings, business retreats. There's storage. There's storage right now, right there. Perhaps most significantly, though, the city keeps inventing extra textual distinctions like owner-present treatment versus absentee owner treatment. At the outset, the city argued that exclusively modified the entire phrase by a person or group of persons. Later, the city reversed course, conceding that exclusively modified only by a person or group of persons, omitting the word for lodging. This directly contradicted the first reading, an interpretation which the city submitted twice, and it raises the obvious textual question: if that is correct, what work does the word exclusively do here? The court knows that each word must be given meaning, and this reading essentially mutes the word that is subject to all this controversy. This ordinance has already been declared unconstitutional once, but then on a motion to reconsider, this is a special judge 4 years ago, said that no, they don't have a fundamental property right. We would submit that he was right the first time. There's also 2 other cases in the same court on the same ordinance right now. But then in its appellate brief, the city abandoned both earlier readings, each previously argued twice, and offered a new theory. It now claims the ordinance bans short-term rentals only when the dwelling is for short-term rentals and used exclusively by the short-term renters, absent the owner, asserting that short-term rentals are permitted, but only when the owner is physically present at the time. But that condition appears nowhere in the ordinance and is rationalized by comparing the 2016 ordinance to a 2018 state statute that did not exist at the time. This is what their brief said. The city's ordinance is more permissive, allowing short-term rentals when the property owner is present. Thus, this is the clear reason the city used the term exclusively rather than wholly or partially, so that the owner, having a vested interest in the property and in the neighborhood, accounts for both. In other words, the city would have this court believe that the clear reasoning for using that word was due to a statute that did not exist for 2 more years.
Yeah, so when it comes to this ordinance, is your argument that it's clear and that it is limited to properties where the lodging is less than 30 days each instant? Or are you saying, well, it's unclear, there's ambiguity here? And because I'm wondering why the rule of lenity doesn't come into play here.
Sure. Well, I'm glad you asked me that, because I should have been more clear myself. I'd say our first argument is it's a fundamental right, and this isn't clear express. Our next one would be vagueness, just because this city of Knoxville versus Entertainment Resources case. If the enforcing personnel cannot explain what is being enforced, then it's probably unconstitutional. If those are not in play, then we would argue that the plain meaning lenity and what you've spoken to, we would argue that we just didn't violate it. If it is clear enough to enforce, if it's not too vague, we would argue that we just didn't violate it.
Okay, I think your time is up for now.
Thank you.
May it please your honors, my name is Lance Ray. I'm here on behalf of the city of Hendersonville. It's a pleasure to be before you. This case concerns a straightforward and constitutionally valid zoning ordinance that prohibits the operation of a short-term rental when a dwelling is used exclusively at the time of the rental solely for short-term renters. In other words, the word exclusively in this ordinance means solely or only, and when read in context, it refers to the nature of the occupancy at the time of the rental. This ordinance was adopted in 2016. So for the last 9 years, the city has regulated short-term rentals and has enforced this ordinance for short-term rentals on properties where the owner is not present at the time that that is being rented short-term.
So you make that argument in your brief that it's the plain meaning to prohibit STRs in residential districts when residences are not owner occupied. I don't see the words owner occupied in this ordinance. How are you getting, and it looks like we're adding words there. So
Well,
where is that coming from?
Yes, Your Honor, thank you. That is just by way of, that is not part of the ordinance. That is just by way of explanation. I believe when we have short-term vacation rentals in our city and they are not owner occupied, it heightens our alertness that it could be used when when the owner is not there. But there is no requirement that it be owner occupied. It's not in that ordinance. And if I conveyed that, I apologize. But
So is the ordinance then violated by an owner occupied? If I own a house in Hendersonville and I rent out the basement for short-term rentals, am I violating the ordinance?
you're on property at the time?
I'm on
of
the
rental?
property at the time.
I'm sorry, you are?
If I am, I'm on the property at the time.
No, Your Honor. No, it's just used, if the entire dwelling is turned over to paying guests with no owner or long-term occupant present, it is being exclusively used as a short-term rental during that stay. And the logic behind that, Your Honor, is that when this ordinance was adopted, there were a lot of, or some of these instances of loud noises, partying and everything. And the logic that the Board of Mayor and Aldermen used at the time was that if there's an owner or someone with interest in the property there at the time, they're going to have a vested interest in what's happening on that property. They're going to have a vested interest in what's happening in that neighborhood. When the owner is not there, there is no one that has that vested interest. And that's the sole purpose and to me, and I would argue, the unambiguous meaning of the ordinance for exclusive use. The use is determined at the time that it's being used exclusively.
Opposing counsel notes, though, there have been some changes in terms of the city's understanding of this provision, and that seems to undermine the contention that this is unambiguous. And do you dispute that? And has the city had a consistent understanding of this provision and how it operates and what exactly exclusively is modifying?
Absolutely. I believe the city has been 100% consistent on how it's enforced this ordinance. We've had instances where a short-term vacation rental was reported as such, and it was found that the owner was on property at the time, and those were not proceeded against. But this is
Isn't there a difference, though, between enforcement and how you've interpreted it in the context of this case? And opposing counsel's not necessarily taking issue with other enforcement or non-enforcement,
Yes.
But essentially says you've read it differently in the context of this case itself.
Well, opposing counsel says that we have different interpretations and we've conveyed different interpretations, but I don't believe that we have done that. I believe we have been consistent. The city has been consistent since 2016. I've been the city attorney for the last 2 years, so maybe the last 2 years for me, is that if the property owner is there, then that does not fit into a violation of the ordinance. So that.
But you would say a property falls within the ordinance as long as they have any rentals less than 30 days. So if let's say they rent it out 6 months out of the year, and then the other 6 months it's for terms of 7 days, that would still fall within the ambit of this ordinance.
Yes, Your Honor, it would.
Okay.
It would. The opposing counsel, who is also the owner of the property, would argue that if he has one 30-day lease, then he is free to do whatever he wants to, short-term rental. And as the trial court correctly stated, that does not fall within the intent of the ordinance, which is to restrict.
Yeah, but I think if anything, our Supreme Court's telling us we really don't care about intent when it comes to construing ordinance and statutes. We really care about meaning. And I have to say, looking at this, it looks like to me it means exclusively for terms of less than 30 days.
So by that, Your Honor, it would again suggest that if someone has one rental of 30 days, then they are free to do with
They
it.
had a rental of 31 days.
Yes, Your Honor, sorry.
That would take them out.
That means that if anybody produced a 31-day lease to the city with the city not being able to prove otherwise, then therefore there is no
That would
short-term.
take them out. The way this is drafted, that looks to me like the meaning here above these words that were used in the ordinance.
I respect Your Honor's opinion for sure, but I would respect.
And look, if you can tell me how to pick this apart and read it a different way, I want to hear it for sure.
Sure.
But, because of that, that's why I mentioned the rule of lenity and the other one. This ordinance imposes a penalty, and if we determine it's ambiguous, we've got to construe it in such a way that avoids application of that penalty. And, I think that's where we're potentially headed here with this sort of language. I also agree with Judge Usman, this is a really awkward way to describe a non-owner occupied property by saying it's exclusively by a person or persons for lodging. Seems like to me there needs to be another sentence in there somewhere.
Would it exclusively apply to lodging as well?
I'm sorry, Your Honor?
Does exclusively apply to lodging as well? So if you rent the house for 2 weeks to store a boat, for somebody to store a boat, does that take it out of the ambit of the ordinance?
If you rent it out for 2
Let's
weeks?
say 2 weeks.
Yes, sir. Is the owner on the property at the time?
No.
Then I would say that is a violation of the ordinance. It's read in full context.
But if it's used exclusively by a person or group of persons for lodging, what if nobody's living there? They're just storing the boat there.
Then, no, my argument, Your Honor, would be that it doesn't just modify the word lodging, but lodging is included. And in the full context of the ordinance, it is that during the rental use for lodging for 30 days or less, if the total occupation is just short-term renters, then that is a short-term vacation rental.
Okay, so my example is not a short-term vacation rental
Because they didn't lodge there?
because they didn't lodge there.
No, that is correct. Yes,
Okay.
that would be the city's position, Your Honor, yes.
Counsel, in responding to opposing counsel's brief, you noted that they had cited cases involving covenants as opposed to ordinances, and the citation does seem to be misplaced. But with regard to ordinances, the Tennessee Supreme Court has said ambiguities in zoning ordinances that would restrict a property owner's free use of property are construed in favor of the property owner's unrestricted use of the property. So while you're correct on the point that the citation refers to covenants, isn't opposing counsel right in terms of the principle that if it is ambiguous, that the Tennessee Supreme Court has directed us to interpret it in such a way as to allow the property owner to use the properties? Now, I know you're saying it's not ambiguous, right? So we never get to that step. But if it is ambiguous, even though you're right on the citation issue, isn't opposing counsel right on the broader principle in terms of how you interpret ambiguities in the context of an ordinance that restricts property usage?
With regard to zoning ordinances, I believe, if I understand correctly, that the law is still that's determined on a rational basis test, so long as
They can impose zoning ordinances, but when we're figuring out the scope of the application, and isn't that something where ambiguity, it favors the property owner? And if they want to say no short-term rentals, you can't have somebody there for less than 30 days and state it clearly, and that's rational basis. But in trying to figure out if that's what the statute does, and doesn't it, if there is ambiguity, don't we have to read it in favor of the property owner's use?
I believe the law still in Tennessee is that then the fact finder would find the intent, the full context, and the purpose of the zoning ordinance.
Well, following up on Judge McBrayer's point, and the Tennessee Supreme Court does seem to have had a transition from purpose to text in terms of analysis. And part of that transition, right, is driven by the exceptions. And how do we, the broad purpose here, restricting short-term rentals, okay. But what are the exceptions? What are the limitations? I mean, one could read this essentially as the city of Hendersonville doesn't want to have properties that are exclusively short-term rentals, and that was the compromise. And it's a fairly modest restriction on short-term rentals. It's a restriction upon short-term rentals. And isn't that one of the challenges of looking at purpose in general, is it's hard to see where the exceptions are, what the limitations of the purpose are, and that's why we're primarily focused on the text itself?
I believe it can be challenging, but I believe also if the law is that once you find ambiguity, then the second step is to find context, purpose, and intent. And those, I believe that there's no restrictions upon which you can go to look for those things, the preamble being one of them, which is a case that I cited in my brief. Listening to the deliberation of a legislative board, looking at anything that has to do with the deliberation of the ordinance becoming adopted. But yes, I believe that if there's ambiguity, then the second step is to find intent and context and purpose. But with a covenant, with a restricted covenant, I don't think that applies.
Well, we've got here language, whereas it has been determined by the Board of Mayor and Aldermen of the City of Hendersonville that it is necessary to impose restrictions on the use of homes as vacation rentals in order to protect the residential character of the residential zones in the City of Hendersonville. I mean, that tells us that it's necessary to impose restrictions, but does it tell us what the extent or scope of those restrictions are? I mean, we know they're trying to impose some restrictions, but do we know how far it goes and what the limitations are with regard to by that purpose language?
I believe if you read in context of the ordinance itself, that if the goal and the intent and the purpose from the city was to restrict short-term vacation rentals and preserve residential neighborhoods, then reading the language of the statute that it's only that a short-term rental is defined as exclusive, that short-term rental is exclusively used at the time of the rental. It doesn't say the time of rental, but exclusively for lodging by people or persons for less than 30 days. I would argue that is clear, that that's what the city was trying to do, was trying to find some middle ground to allow people to home share if they want to rent out, as the state definition says, wholly or partially. The city, now that the state definition came out 2 years after the city's definition, and I never said that the city relied upon that. My argument, and the trial court may have misunderstood that, but my purpose for bringing that up was to convey the parallel and the city's definition in 2016, and then the state came out with a definition in 2018. The city said exclusively, and the state said wholly or partially, pretty much in the same format and context. And the city was trying to find a balance between allowing people to use their homes, rent out a room, but not be on property at the time, because there's no one there that has a vested interest in the property, in the neighborhood at the time of the rental. Your Honor, I would lastly, unless there's any other questions, just respectfully submit that Judge Thompson, who is very much more learned than I am in the trial court, looked over this. We had 4 hearings on this, as the appellants referred to in their argument or in their brief. We had 4 different hearings arguing this before Judge Thompson, and he found ultimately that, of course, it would be an absurd result to say that the city wasn't trying to restrict these rentals or preserve their neighborhoods by saying that they could rent for 30 days or 31 days and then be unlimited to what they wanted to do. read out. So we would respect, I'm sorry.
No.
I was just gonna say, we would respectfully ask your honors to affirm the trial court.
Thank you.
Thank you, thank you.
This owner-present position that is being advocated by the city leads to absurd results. A homeowner who lives in her home but leaves for work, for church, to go to the hospital, has an emergency, has to pick a child, she's deemed absent and therefore barred from renting her home during those absences. Some things happen and we just can't plan them, but by this position, that would be the determinative factor on whether or not you're legal or illegal. Hendersonville Police enforce this ordinance as though such a rule exists. It's even outlined on the city's website right now. That is the rule. And finally, the trial court adopted a construction entirely of its own, holding during oral rulings that exclusively modifies a dwelling unit or other structure rented or used. This interpretation that was used to grant the city its trial court victory has not even been argued by the city itself. Yet it now stands as the controlling ruling below. The city has not even asked you to adopt it. In conclusion, this is just not what clarity looks like. 4 different interpretations of one sentence cannot restrict a fundamental property right. Even the judge called the ordinance not a model of clarity and referred to it using the term vagueness at one point. We ask this court to follow City of Knoxville versus Entertainment Resources, LLC, declare the ordinance unenforceable, however the court chooses to do that, vacate the trial court orders, and remand for determination of damages caused by the injunction. Thank you.
Thank you. Thank you both. We have concluded today's docket, so would you please adjourn us until tomorrow morning?